Hello Year 11s and welcome to this video on the Victorian criminal court hierarchy. There are 4 things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you want to go over any information contained in this video. The third thing that you need to do is to have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of key terms or of any other words the meaning of which you're unfamiliar with. And the fourth thing that you need to do is to have your summary books open in front of you. As we go through this video, I will give you guidance as to what you should write in your summary books. Once you've finished watching and taking notes on this video, make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then make sure that you supplement your Cornell notes with that additional information. Well, let's get started then. Here are the learning intentions for this video. Make sure that you write these learning intentions down in your Cornell notes. By the end of this video, you should be able to do 2 things. The first thing is that you should be able to describe the criminal jurisdictions of the Victorian court hierarchy. The second thing that you should be able to do is explain the reasons for a Victorian court hierarchy in determining criminal cases, including specialisation and appeals. Here are 4 very important definitions. In your vocabulary sheets, look down the left-hand side, find each of these defined terms, and opposite the relevant term, write in the corresponding definition. The first term that you need to be able to define is court hierarchy. A court hierarchy is the ranking of courts according to the seriousness and complexity of the matters they deal with. In your definition, highlight the words ranking and seriousness and complexity, and if ever you're asked to define the term court hierarchy, make sure that you use those highlighted words in your definition. As you know, and as I will show you later on in this video, the High Court is at the top of each of the state and territory court hierarchies, including the Victorian criminal court hierarchy. The High Court deals with the most serious and complex cases. This is because parties are only likely to appeal a case all the way to the High Court where that case is a very significant case and the case involves difficult questions of law. Also, because the High Court is at the top of each of the state and territory court hierarchies, its decisions are very important as there is no appeal from them. This is because there is no court above the High Court which could hear appeals from High Court decisions. This puts the High Court in a very special and powerful position. On the other hand, the Magistrates' Court is at the bottom of the Victorian criminal court hierarchy because it deals with small matters. For example, it hears summary offences such as drink driving and minor assaults, which are minor offences. In addition, because the Magistrates' Court is at the bottom of the Victorian criminal court hierarchy, the Magistrates' Court doesn't hear appeals from any court. There is no court below the Magistrates' Court from which an appeal could be made to the Magistrates' Court. The second term that you need to be able to define is jurisdiction. Jurisdiction is the extent of the power of a court. That is, the jurisdiction of a court refers to the types of cases that the court can deal with. In your definition of jurisdiction, highlight the word power and make sure, if you're ever asked to define the term jurisdiction, that you include that highlighted word in your definition. So, for example, the Magistrates' Court has the jurisdiction or power to hear summary offences such as minor assaults. On the other hand, the county court and the trial division have the jurisdiction to hear indictable offences such as burglary, kidnapping and rape. The magistrate's court does not have the jurisdiction to hear these kinds of offences, so you will never see a trial for burglary, kidnapping or rape occurring in the magistrate's court. In addition, only the trial division has the jurisdiction to hear murder cases, so you will never see a murder trial in either the magistrate's court or the county court. You will only see a murder trial in the trial division. Now, there are two kinds of jurisdiction. The first kind of jurisdiction is original jurisdiction. A court is said to be exercising original jurisdiction when it is the first court to hear that case. That is, original jurisdiction is the power of a court to hear a case for the first time. In your definition of original jurisdiction, please highlight the words power and for the first time, and remember to use those highlighted words whenever you're asked to define original jurisdiction. So, for example, the magistrate's court has original jurisdiction to hear summary offences because when the police charge a person with a summary offence, that person's case is heard in the magistrate's court. Equally, the trial division has original jurisdiction to hear murder cases because when the police charge a person with murder, that person's trial is held in the trial division. The second kind of jurisdiction is appellate jurisdiction. A court is said to be exercising appellate jurisdiction when it hears an appeal from a lower court. That is, appellate jurisdiction is the power of a court to review the decision of a lower court. When a court hears an appeal, it is reviewing the decision of the lower court to correct any mistakes that the lower court has made. In your definition of appellate jurisdiction, please highlight the words power and review. If you're ever asked to define the term appellate jurisdiction, make sure that you use those highlighted words in that definition. You'll note that we don't simply define appellate jurisdiction as the power of a court to hear an appeal. That would be circular. It doesn't demonstrate that we know what appeal means. That's why we use the word review. Now, remember that even though a party will often appeal the decision of a court with original jurisdiction to a higher court, it's also possible for there to be an appeal from the decision of the court that hears that appeal. So, in other words, it's possible for a case not just to be heard a second time, which is where there is an appeal from the court with original jurisdiction, but the case might also be heard a third time. That is, where there is an appeal from the court that hears the appeal from the court with original jurisdiction. In fact, there might yet be another appeal, which means that the case is heard for a fourth time. For these reasons, it is not correct to say that appellate jurisdiction is the jurisdiction to hear a case for a second time. As I've said, a case could be heard for a second time, but it could also be heard for a third or even a fourth time. That's why we define appellate jurisdiction simply as the power of a court to review the decision of a lower court. An example of appellate jurisdiction is the jurisdiction of the Court of Appeal. In fact, the Court of Appeal only hears appeals. In particular, it hears appeals from decisions of the county court and the trial division. For instance, let's suppose that an accused is convicted of burglary in a trial that is held in the county court and that the judge sentences the accused to 10 years imprisonment. If the accused thinks that this sentence is too long, then the accused can appeal against that sentence to the Court of Appeal. If the Court of Appeal agrees with the accused that the 10-year sentence is too long, then the Court of Appeal will reduce the length of the accused's sentence, say to 6 years imprisonment. This is an example of the Court of Appeal exercising appellate jurisdiction. The Court of Appeal reviewed the decision of the county court and corrected the mistake made by the county court, which was to impose a sentence on the accused that was too long. Note that the appeal is brought by the dissatisfied party, in this case by the accused who is dissatisfied with the length of sentence that has been imposed by the county court. You must never say that a court appeals its decision to another court. It is a party who appeals a court's decision to a higher court. Let's now look at the Victorian criminal court hierarchy in a bit more detail. At the very bottom of this hierarchy, we have the Magistrates' Court, which deals with all kinds of summary offences. As you know, proceedings before the Magistrates' Court are called hearings. Above the Magistrates' Court, we have the County Court, and above the County Court, we have the Trial Division of the Supreme Court. Both the Trial Division of the Supreme Court and the County Court deal with indictable offences. Where an accused person pleads not guilty to an indictable offence, then their case is brought before the Trial Division of the Supreme Court or the County Court, and that proceeding is called a trial. Above the Trial Division of the Supreme Court, we have the Court of Appeal. You can see that the Supreme Court consists of two parts. The first part is the Trial Division, which, as its name suggests, deals with trials of accused people for indictable offences. The second part is the Court of Appeal, which again, as its name suggests, deals with appeals. Above the Supreme Court, we have the High Court. The High Court is a federal court, unlike all of the other courts in this diagram, which are Victorian courts. There is only one High Court in Australia, and it sits at the top of each state and territory court hierarchy. In this slide, I will set out in diagrammatic form the original jurisdiction and the appellate jurisdiction of each of the courts in the Victorian criminal court hierarchy. This is a very important diagram which you need to include in your summary books. It will provide you with a very useful point for revising your knowledge of the original and appellate jurisdictions of each of these courts. Well, let's start at the bottom of the Victorian criminal court hierarchy with the Magistrates' Court. The Magistrates' Court has original jurisdiction to hear summary offences, such as minor assaults, and indictable offences that are heard and determined summarily, such as theft of a motor vehicle. In addition, the Magistrates' Court hears committal proceedings for indictable offences, applications for bail, and applications for search and arrest warrants. A committal hearing is held in the Magistrates' Court where an accused has been charged with an indictable offence. At the committal hearing, a magistrate decides whether the prosecution's evidence is of sufficient weight that a jury could convict the accused at a trial. Now, the mere fact that the Magistrates' Court hears committal proceedings for indictable offences does not mean that the Magistrates' Court has original jurisdiction to hear indictable offences. It does not. The only courts that have original jurisdiction to hear indictable offences are the County Court and the Trial Division of the Supreme Court. This is because, although the Magistrates' Court hears committal proceedings for indictable offences, that hearing is not a trial to determine whether the accused is guilty or not guilty of the indictable offence. It is only if the magistrate commits the accused for trial in the County Court or the Trial Division of the Supreme Court that the accused's guilt will be determined at a trial of the accused in the County Court or the Trial Division of the Supreme Court. Conversely, if the magistrate decides that the prosecution's evidence is so weak that no jury could reasonably convict the accused at a trial, then the magistrate will discharge the accused, and so the accused has no trial in the County Court or the Trial Division of the Supreme Court. Instead, the accused is free to go. Because the Magistrates' Court is the lowest court in the Victorian criminal court hierarchy, it has no appellate jurisdiction. There is no court below the Magistrates' Court from which appeals can be brought to the Magistrates' Court. We now move up the Victorian criminal court hierarchy to the County Court. The county court has original jurisdiction to hear all indictable offences except the most serious, which are murder and treason. In addition to having an original jurisdiction, the county court also has an appellate jurisdiction. The county court hears appeals brought by a party from a decision of the magistrate's court. There are 3 grounds on which a party can appeal a decision of the magistrate's court to the county court. The first ground on which a decision of the magistrate's court can be appealed to the county court is where the accused appeals against their conviction in the magistrate's court. In such a case, the accused has been found guilty in the magistrate's court and is appealing to the county court to have their conviction overturned on the basis that they should not have been found guilty, but instead they should have been found not guilty. The second ground on which a decision of the magistrate's court can be appealed to the county court is where the prosecution appeals against the leniency of the sentence that the accused has received in the magistrate's court. In such a case, the accused has been found guilty in the magistrate's court and the magistrate has imposed a sentence on the accused, but the prosecution believes that that sentence is too light. The third ground on which a decision of the magistrate's court can be appealed to the county court is where the accused appeals against the severity of the sentence that the accused has received in the magistrate's court. In such a case, the accused has been found guilty in the magistrate's court and the magistrate has imposed a sentence on the accused, but the accused believes that that sentence is too heavy. Moving yet further up the Victorian criminal court hierarchy, we come to the trial division of the Supreme Court. The trial division has original jurisdiction to hear all indictable offences, including the most serious indictable offences, which are murder and treason. In addition to having an original jurisdiction, the trial division also has an appellate jurisdiction. The trial division hears appeals from the magistrate's court on points of law. What this means is that either the prosecution or the accused can appeal a decision of the magistrate's court to the trial division on the basis that the magistrate has made an error of law or has misapplied the law. The final court that we need to look at is the Court of Appeal. As its name suggests, the Court of Appeal hears appeals. That is, the Court of Appeal does not have any original jurisdiction. Instead, it only has an appellate jurisdiction. The Court of Appeal hears appeals brought by a party from a decision of the county court or the trial division. There are 4 grounds on which a party can appeal a decision of the county court or the trial division to the Court of Appeal. The first ground on which a decision of the county court or the trial division can be appealed to the Court of Appeal is on a point of law. What this means is that either the prosecution or the accused can appeal a decision of the county court or the trial division to the Court of Appeal on the basis that the judge in the county court or the trial division has made an error of law or has misapplied the law. The second ground on which a decision of the county court or the trial division can be appealed to the Court of Appeal is where the accused appeals against their conviction in the county court or the trial division. In such a case, the accused has been found guilty in the county court or the trial division and is appealing to the Court of Appeal to have their conviction overturned on the basis that they should not have been found guilty, but should instead have been found not guilty. The third ground on which a decision of the county court or the trial division can be appealed to the Court of Appeal is where the prosecution appeals against the leniency of the sentence that the accused has received in the county court or the trial division. In such a case, the accused has been found guilty in the county court or the trial division, and the judge in the county court or the trial division has imposed a sentence on the accused, but the prosecution believes that that sentence is too light. The fourth and final ground on which a decision of the county court or the trial division can be appealed to the Court of Appeal is where the accused appeals against the severity of the sentence that the accused has received in the county court or the trial division. In such a case, the accused has been found guilty in the county court or the trial division, and the judge in the county court or the trial division has imposed a sentence on the accused, but the accused believes that that sentence is too heavy. We now come to our second learning intention. This learning intention is that you should be able to explain the reasons for the Victorian criminal court hierarchy, including specialisation and appeals. You may remember that there are actually 4 reasons for a court hierarchy, that is, specialisation, appeals, administrative convenience, and precedent. However, according to the curriculum, the 2 key reasons for a Victorian criminal court hierarchy are specialisation and appeals, and so these are the 2 reasons that we'll be focusing on and that I want you to use if you're answering a question in a SAC or exam about the reasons for a Victorian criminal court hierarchy. This is different from the Victorian civil court hierarchy, which we'll be looking at in Unit 2. In that case, the curriculum emphasises administrative convenience and appeals as being the 2 key reasons for a Victorian civil court hierarchy. This brings me to an important point that often trips students up. Read the question carefully. If the question is asking about the reasons for a Victorian criminal court hierarchy, then make sure that any examples you give relate to the Victorian criminal court hierarchy. If the question is about the reasons for a Victorian civil court hierarchy, then make sure you give examples that relate to the Victorian civil court hierarchy. Of course, if the question just relates to the Victorian court hierarchy, you can use examples from either the Victorian criminal court hierarchy or the Victorian civil court hierarchy. The table on this slide and the next slide describes and explains specialisation and appeals as reasons for having a Victorian criminal court hierarchy. Please copy this table into your summary books and supplement this table with any additional information that you think will help you remember and explain the reasons for a Victorian criminal court hierarchy. You will see that we can explain these 2 reasons by using the counterfactual if there was no criminal court hierarchy then. This is a good technique for answering a question about the reasons for the Victorian criminal court hierarchy because it highlights the advantages of that court hierarchy by highlighting the disadvantages if there was no court hierarchy. In a moment, I'll show you what I mean. As I have said, the first reason for having a Victorian criminal court hierarchy is specialisation. Look down the left-hand side of your vocabulary sheets, find the word specialisation and write this definition in there. Specialisation means different courts have different areas of expertise. You will note that we do not define specialisation as different courts having different specialties or specialisations because this is a circular definition and does not show that we understand what is meant by the term specialisation. So, highlight the word expertise in your definition and make sure that you use this word whenever you define specialisation. Importantly, you need to be able to give examples of how courts in the Victorian criminal court hierarchy have different areas of expertise. Well, here are some examples. First, the Court of Appeal has expertise in criminal appeals. Remember that the only jurisdiction that the Court of Appeal has is an appellate jurisdiction. Typically, 3 judges sit together in the Court of Appeal when it is hearing appeals. This is because the Court of Appeal hears appeals from decisions made by judges in the County Court and the Trial Division of the Supreme Court. So it's appropriate that these appeals should be determined by more than one judge because the original decision is made by one judge. Because the Court of Appeal only deals with appeals, then it has expertise in deciding appeals in criminal cases. The second example of specialisation relates to the trial division of the Supreme Court. Because the trial division of the Supreme Court is the only court that has original jurisdiction to hear murder trials, then we can say that the trial division has expertise in murder trials. A third example is that because both the trial division of the Supreme Court and the County Court have original jurisdiction to hear indictable offences, then both the trial division and the County Court have expertise in indictable offences. And here's a final example in the Magistrates' Court. The Magistrates' Court has original jurisdiction to hear summary offences, and therefore we can say that it has expertise in summary offences. Now you can see why we need to have a Victorian criminal court hierarchy for there to be specialisation. This is because specialisation can only happen where there are different courts, so that the judges in those courts are always dealing with the same types of criminal cases. It is in this way that those judges will become experts in particular types of criminal cases. It's like playing soccer. The only way you can become an expert at playing soccer is if you practice playing soccer every day. It is unlikely that you'll become a top-class soccer player if you only play soccer on Mondays and play tennis, football, table tennis, cricket, volleyball, and water polo on the other days of the week. Using the counterfactual, if there was no criminal court hierarchy then, we could explain this reason for having a Victorian criminal court hierarchy by saying, if there was no criminal court hierarchy and there was only one court that dealt with all cases, then there would be no specialisation because the judges in that court would not just deal with particular types of criminal cases and so would not be able to build up expertise in those types of criminal cases. Let's now look at the second reason for having a Victorian criminal court hierarchy, that is, appeals. In an appeal, a party that is dissatisfied with the decision of a lower court requests a higher court to review the decision of the lower court so that the higher court can correct any mistakes in the lower court's decision. Look down the left-hand side of your vocabulary sheets, find the word appeal and write this definition in there. You'll note that we don't just define an appeal as where a party appeals a decision of a lower court to a higher court, because this doesn't demonstrate that we understand the meaning of appeal. So, in your definition, highlight the word review and make sure that you use this word whenever you are defining an appeal. As we've seen, either the prosecution or the accused can appeal a decision of a lower court to a higher court in a criminal matter. Whichever of the prosecution or accused brings the appeal, that party is called the appellant. The other party, that is, the party against whom the appeal is made, is referred to as the respondent. Note also that it is a party which brings an appeal against a court's decision. It is not correct to say, for example, that the trial division appealed its decision to the Court of Appeal. Instead, it is a party to the case before the trial division that can appeal a decision of the trial division to the Court of Appeal. Now, in the diagram that you've already included in your summary books, you have a number of examples of appeals in the Victorian criminal court hierarchy. First, a party can appeal a decision of the Magistrates' Court to the trial division, or a decision of the County Court or trial division to the Court of Appeal, on a point of law, that is, where the party believes that the lower court has made an error of law or has misapplied the law. Second, an accused can appeal against their conviction in the Magistrates' Court to the County Court, or against their conviction in the County Court or the trial division to the Court of Appeal. In such a case, the accused is saying that they should not have been found guilty in the lower court. Third, the prosecution can appeal to the County Court against the leniency of a sentence that has been given to an accused in the Magistrates' Court, and the prosecution can appeal to the Court of Appeal against the leniency of a sentence that has been given to an accused in the County Court or the trial division. And finally, fourthly, the accused can appeal to the county court against the severity of a sentence that has been given to the accused in the magistrate's court, and the accused can appeal to the Court of Appeal against the severity of a sentence that has been given to the accused in the county court or the trial division. I should also mention that it can be dangerous for an accused to appeal against their sentence to a higher court. This is because the higher court could decide that the sentence is not tough enough, and so the higher court could actually decide to increase the accused's sentence. Now you can see why we need to have a Victorian criminal court hierarchy for there to be appeals. If you didn't know what courts were higher or lower than other courts, you wouldn't know what court you could appeal from or to. Using the counterfactual, if there was no criminal court hierarchy then, we could explain this reason for having a Victorian criminal court hierarchy by saying, if there was no criminal court hierarchy then, there would be no appeals because there would be no higher courts and no lower courts, and so a party would not be able to have a higher court review a lower court's decision. That brings us to the end of this video on the Victorian criminal court hierarchy. You should now be able to do two things. First, you should be able to describe the criminal jurisdictions of the Victorian court hierarchy. And second, you should be able to explain the reasons for a Victorian court hierarchy in determining criminal cases, including specialisation and appeals. Remember, there's one more thing that you have to do. Please make sure that you read the pages from the textbook referred to on the first slide. And if you find any additional information from those pages that you think is useful, make sure you supplement your Cornell notes with that additional information. Thank you very much for your attention.